Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley, and thanks again for joining. It's the wonderfully winter month of February, and we've been kind of going through some of the issues dealing with child-related matters in a divorce, and specifically, we've talked about the importance of a schedule as really a starting point. We've talked then about decision-making and the importance of that. And today we're going to diverge a little from the macro and focus a little bit on the micro in terms of a specific issue within issues we face having to do with family law, child-related issues, and that being matters of relocation. And relocation is interesting because historically, we used to refer to it here in Illinois as removal, and it historically was in the context of removing the children from the state of Illinois to a different state. The laws within the state of Illinois have changed within the last, less than 10 years, certainly. And there's now a restriction placed even within the state of relocating from the marital residence beyond 25 miles. So we're going to focus more in the context of out of state, but a lot of what we're going to talk about today is also applicable in the context of moving within the state. You're living in the city of Chicago, you want to move to a different county, and that county is still within the state of Illinois, but it could be, 100 miles away, and it could be a 2-hour drive. That requires a specific procedure, whereas in the old days, you can move around within the state. So what is really entailed in relocation then is a request by one party, and it can be during a divorce and it can be after a divorce. It just really is the same protocol, the same mechanisms, the same litigation, because the concept is one parent is seeking to move a child from the state of Illinois to some other state. So what happens in that context? If you're in a situation where you're in the middle of a divorce, and let's create a hypothetical that, for example, let's say mother has been home with 3 children as a homemaker and a mother. Husband had been out as the primary wage earner, and husband, as the primary wage earner, travels a lot. He's busy during the week, not really able to have much interaction with the children, but is involved with the kids on the weekends. Mom, for example, under a hypothetical, doesn't have a lot of, maybe there's not a lot of financial support in the family. Maybe husband doesn't earn a tremendous amount of money, but mom has family. Let's use Illinois as the base camp. That's where we are. And let's imagine mom wants to move to Ohio. And why do I say Ohio? Is because I tried a very significant relocation case, and that was an attempt by mom in that case to relocate to Ohio. So in that context, let's add to the hypothetical that mom would have financial support there. Mom would have extended family, and the kids have cousins there, and some other things are good schools, activities, all kinds of things where the life in Ohio would be a nice life, okay? Let's also add to the hypothetical that in moving, you could drive to wherever in Ohio, make up whatever the city, but let's say it's a 6-hour drive, okay? So these are the kind of things, and the reason that, I throw some of these things at you is because they all matter, right? Relocation isn't a one-issue determination. We have to look at factors that the court's going to consider in this. And to the extent it's a very global look, because they really want to get at what's in the best interest of the children. And I think you have to understand, anybody seeking to relocate to another state, you have an uphill battle as a starting point. Doesn't mean it can't happen. We've tried cases, we've been successful. We've been way more successful in blocking people from relocating in cases we've tried and litigated, because there is a natural recognition that if mom and dad are in different states, the person who's not going to have primary care of the children, is going to have a fundamentally different relationship with the children, not seeing them regularly, maybe seeing them once a month. And I'll talk about kind of what's a typical relocation schedule, what you often see, one parent in one state and another here in Illinois. But as a starting point, if you're seeking to relocate your children to a different state, you really have to go through a litany of questions, factual questions, and ask yourself and be able to see whether you have evidence to support why are you requesting that move. And it's not going to be as simple as, well, the weather's warmer. Okay, I had a client who relocated with her son to Florida. Of course, the weather was warmer in Florida, but that wasn't a determining factor. Okay, there's a lot more to it. So you have to ask yourself these questions. Starting with, what's the motive? Courts will examine that, right? Are you historically, or is there evidence historically of one parent maybe alienating the children from the other parent? And are they, hey, this is my way to get the kids even further away from their father or from their mother, okay? Are the motives pure or are they not pure, right? I've got a new job, and the job is going to help give me and therefore my children this amazing life, opportunities they would not have otherwise had if I stayed here in Illinois. Okay, it's a pure motive, right? Oftentimes, you get the remarriage in post-decree matters. And while some will question whether or not that's a very powerful motive, you know, if you get remarried and your new spouse is from, for example, Ohio, a court may not necessarily look at that as a negative motive, okay? But it may not really carry much weight with the court because, again, you made a decision, you got remarried, great, good for you. But you've got your children, and what we're looking at, says the court, in a case of a relocation, is how is the relocation going to impact the children? How is it going to impact the children's relationship with the other parent that's being left behind? So motives are important. Factually, you want to look into the issues of what's the benefit? How is there an enhancement of the child's life going there? What are the schools like when you compare? What are the neighborhoods the child's going to live in? What are the economic circumstances if the child moves to this new? Are they going to have a nicer house and a big yard and in a safer community? All of these things have to be looked at and considered. But oftentimes, I think what it really comes down to is when you peel through all the factors, a lot of relocation comes down to the impact it's going to have on the children and the relationship they have with the parent being left behind. I mentioned the Ohio case. I tried a case, and mom, post-decree, in other words, already divorced, remarries. New blended family. She gets pregnant by the new husband. New husband is from Ohio. He's got his family there. He's divorced. He's got his parenting schedule with his kids in Ohio. And so mom says, we want to pack up, move out of Illinois, and go to Ohio. Well, in that case, one of the things we emphasized was dad's relationship with the children. He wasn't an every other weekend dad. You know, sometimes you hear this sort of dismissive term of the Disney dad, you know, as though a father who works during the week and maybe doesn't have as much available time and he's with them on the weekends, he's just there to provide fun. You know, that's disrespectful in many cases, but in the context of whether the court can replicate a schedule, if there is a relocation, that's similar to, or doesn't have to be exact, but I mean, can you somehow mirror the amount of time dad, in this case, is spending with the children, you know, in Illinois now versus if they were in Ohio? And sometimes you can do that, right? Because sometimes the other parent just doesn't have a lot of time around their schedule to be interacting with the children, be at all the events, be at all of the, the school stuff and so forth. In this particular case that I tried, we pointed out the fact that wasn't our guy. You know, dad was at all the school functions. Dad's parents, so the children's grandparents who lived in the community, very, very instrumental in the children's daily lives. It wasn't, hey, we see grandma and grandpa on, a holiday here or there and those types of things. And no, they were at grandma and grandpa's house quite regularly, and they lived in the community. So that was important to this community. The kids were very involved in sports. And guess what? Dad happened to coach the kids in sports. Dad happened to be a volunteer at school. He did the things that moms and dads do sometimes, where they go in and read stories at the school, or they participate with the parent-teacher conferences, all those things. So by all accounts, unrebutted, Dad was very involved in the children. And it wasn't just on the weekends. In fact, Dad, after the divorce, sought more time with the children as his work obligations changed. So he was having parenting time during the week as well as on the weekends. He was coaching. He was seeing the kids. Even days that were not on his parenting days, he might see the kids because he was coaching. He was going to their school events and so forth. So a lot of contact that we had. And that was something we strategically introduced in that trial. Sometimes what attorneys will do in relocation cases is they'll focus on overnights. Well, he only has overnights on Friday and Saturday, maybe Sunday every other weekend. So he's only got 6 overnights every other weekend. Well, we could have the kids come back on, there's usually one long weekend a month, right, where, whatever this month might be President's Day, and we had Martin Luther King Day in January. There's always sort of that weekend in a kid's school schedule where it's a longer weekend. On those weekends, we'll have the kids come back in town, and he'll have maybe 4 overnights, and so, he's only losing 2 overnights. Overnights is just one part of it, okay? And I have 4 children of my own. So there are periods in the day that you have interaction with your children. They could be brief. In this case, on Dad, he would have an overnight, right? But on the next night, he would be driving the kids to school as well and then go off to work. So that time in the morning, hey, let's get up, kids, have some scrambled eggs, here's your lunch, and we drive to school together. That's a contact. So that's just another day in the week where there's a contact. He doesn't have an overnight that night. Maybe mom does. But that doesn't make it any less insignificant. Those little things along the way. By the way, soccer practice is Tuesday night after school. It's not Dad's overnight, but Dad's at the practice because he's coaching. And, hey, let's go get a cheeseburger or a sandwich after practice, and I'll drop you back off at Mom's. That's a contact during the day. So in that particular case, this is something, free tip, if you're in a situation, map out a calendar of what that looks like. We actually introduced into evidence color-coded calendars that really broke down, and we put a light blue square on every day our client had contact with the children, physical contact, let alone, day or two here and there where you didn't see him, he'd do a FaceTime, what have you. But what you saw was blue all over the calendar. And so when the judge then is sitting there thinking about how do I replicate this amount of blue contact that Dad has had with his 2 children if the kids are living in Ohio, you can't. Because what typically happens, and I mentioned this previously, what typically happens in a relocation case is if it's granted, what usually happens is you see some expectancy on the part of the person relocating to get the children back to, in this case, Illinois, at least once a month. And again, that once a month is usually around a school break, national holiday, sometimes the longer holidays and so forth. So there's at least one long weekend a month. Then there's the invitation to the person in Illinois, hey, by the way, come to Ohio every other weekend. Okay, so now, sure, Dad, you drive 6 hours there to have a weekend, get a hotel, eat restaurants the entire weekend, and then come back and go back to work the next day because we decided to relocate. That's a tough ask. But that's often built into these relocation schedules, saying, you know what, Dad, I'm saying Dad, but the parent that's left behind has generally the right or the ability to go into the town where the children are and visit them there. But again, there's an inconvenience that's created because you moved on with your life, and there's certainly a cost to that. So that's always something that gets baked into the negotiation or the judge's order in terms of who pays for those additional costs. But then you also have summertime, and again, there's oftentimes a shifting of the kids back to the home state for summer. And sometimes it's the entire summer, sometimes it's 6 weeks. It could be whatever is reasonable. But then again, think about that. Think about the challenges that has. My kids were in all kinds of sports, and sports don't stop when school stops, right? They start up. All the travel stuff's going. You've got multiple kids, multiple sports, multiple teams. Summers are chaos. And so now, how do we, if the kids' AAU basketball season runs from, May through August, well, school doesn't even get out in Ohio until June. I'm making this up. So if the child's going to play in Illinois, he's already missed first 2 weeks of the season, the tryouts maybe. And then, by the way, they're going to be there the entire summer, tournaments on the weekends. It's just logistically a challenge, but typically what you see is the parent left behind is usually going to get the bulk or a significant period of time in the summer, and a larger percentage of the time on the holidays, the longer holidays, the winter or Christmas break, at school could be 2.5 weeks, okay? If you're living in the same town, generally speaking, judges are going to split that 50-50. You get a week, I get a week, and that's fair. In this case, the parent being left behind may get a longer stretch. Spring break, same thing. You're in the same town, mom and dad probably going to split, or the parents, I should say, are going to split. You got spring break this year, I've got the Thanksgiving break this year, and we flip-flop the other. But if you're taking a child out of a jurisdiction and their time is being reduced, the expectation is they're going to have more of those holiday breaks from school and try to make up the time they've lost. Because that, again, is a significant charge of the court, is to see, can they in some fashion replicate the amount of contact or the relationship that the parent left behind had now that this relocation occurs. You can see how challenging that is, and you can see why it's so difficult. Any of us, anyone watching, anyone listening, understands relationally. When you're not with somebody, it's a different relationship. And it's probably more impactful with a child because it's not just the relationship, but it's the parenting of the child, what you're teaching them, the things that you just need to be with a child to be able to pass along, to be able to teach, to be able to parent. I suppose you could sit down and you could try to help a child with some homework over Zoom. It's not the same as sitting at the table and working with them. So relocation, for all those reasons, is very challenging as a legal, mechanism. Rightfully, the courts look and say, there has to be a really, really, really good reason for this to happen, to take children and separate them physically by states and expect them to still have the kind of parent-child relationship that we would want for all children. So you get into some of these nuances as well. I've had cases, you think about Ohio. Well, 6-hour drive, you say, well, that's an awful long time. Imagine with a child, taking a child or children, putting them in the car. When do you do it, by the way? Like, what if school gets out at 3:30, and by the time you pick them up, like I said, get them fed, you'd have to have their bags packed, ready to go. And if you're driving from 3 o'clock and you're going to drive 6 hours, there's no parenting time that's going to occur Friday. So the one parent gets them Friday night, kids are exhausted, probably going to want to sleep in on Saturday. You basically have some time Saturday, and if you have the luxury of having the Monday as a school holiday, Monday, you got to get out of there at a reasonable time, right? Maybe you're leaving by noon to get them home by 6 p.m. so they can have a meal, get a shower. It's just not an ideal situation, and the courts recognize that. So you really have to, going back to the beginning, it's like you always have to look at what your motive is. And why am I doing this? And how is this going to be better for the children? I have been successful in relocation cases. We had a situation where, Dad for whatever the reason, just wasn't really involved in son's life, 12-year-old boy. Guy would go over to, 12-year-old would go over to dad's house on a weekend. It was Friday to Sunday night. And by and large, son would be in his room playing video games, and, dad wasn't coaching, dad wouldn't go to the games, dad wasn't really interested in parent-teacher conferences. He just did his every other weekend parenting time. Okay. Not being judgmental one way or another, but that was the facts of that situation. Mom remarried. Mom remarried to a very successful and wealthy physician who had a new position available for him in Florida. And so the fact that she was remarried and had financial security that she wasn't getting, got minimal support from her ex-husband, was now going to have a child who the new spouse of our client was willing to and agreed to pay for private school at a very elite, very highly ranked private school in Florida. And that was a benefit that the child had. The child was going to have a beautiful home, it provided a child a better life. The financial aspects afforded this young 12-year-old better and different opportunities. So that was on the positive side. And the reality of it was, because dad's interaction was so limited, it really didn't impact the relationship. There wasn't that much of a involved, nurturing relationship, and that was a case where we were able to remove the child to Florida. So it really is fact specific. And in the state of Illinois, 9 out of 10 times, it is going to be within the discretion of the judge. So your trial judge is largely going to be the one that's going to make the decision. And what you see in the appellate opinions here in Illinois is they're not going to retry the case. So the facts are what the facts are. You present them as best you can. You got to make sure your lawyer is as persuasive as he or she can be with the facts, with the evidence, to make your case. Because if you lose, whether it's a denial of going there or if it's the granting of it, the reality of it is you're going to have a very, very, very tough time having that overturned on appeal here in Illinois. It's not a situation usually where the court made some sort of error in the applicability of the law. They don't abuse their discretion because they're taking all these very factors and they're making a judgment call. That's what your trial judge does. So bringing that piece to this, relocation too, understand this. I've tried probably more relocation cases, those type of cases, in terms of a percentage of the cases I've tried, more so than any other particular type of issues, even the complex financial issues. Why? Because rarely is there a middle ground. In other words, how do you settle, how do you proverbially split the baby, right? I mean, you can't do that. If it's $1, I can say, all right, you take 50 cents, I'll take 50 cents. You take 75 cents, I'll take 25%. With a child, and mom's going to be in a different state than dad, or the parents are in different states. It just doesn't work. And if one parent says, I have to make this move for whatever the reason is, unless the other parent says, sure, I'm fine with that, go ahead, which doesn't usually happen. In fact, when I've seen that happen, a lot of times it's the other parent says, you know what? I'm going to move to Ohio too because I can. I don't really have anything keeping me here in Chicago. My family's not here. Our life isn't here in the first place. I'm going to move back there too. I'm going to move to Florida because I want to be by our children. That's a lot, and that's rare. So what happens, again, if someone says I want to go, someone says I don't want you to go, there's going to be a trial. And these are not inexpensive trials. There are going to be individuals appointed by the court, whether it's a guardian ad litem or a child's representative, someone who's going to be there to advocate for the best interests of the children in this. By the way, what are the express preferences of the children? That can be a factor, right? if you have a 4-year-old and a 7-year-old, they're not going to have much say. But if you have a 14-year-old and a 17-year-old, and the 17-year-old is a junior in high school, I don't want to go. I want to be able to finish up my senior year here, right? Or I just made the basketball team, and I've been playing with these same kids, since 4th grade. I don't want to start my sophomore year at some other school. So those could be compelling factors that not only the court, but a guardian ad litem, a court-appointed evaluator, could be a psychologist, psychiatrist, mental health professional, they'll take those into consideration. I've had other issues where sibling relationships come into an extended family. So as I mentioned in the one case, the fact that grandma and grandpa were right around the corner and probably on a weekly basis, the kids saw grandma and grandpa. It was a huge factor in that case, because you're not only taking away from dad, you're taking away from their lives, their friends, their grandparents. How entrenched are they in the community? What are they involved in? The more involved kids are, the more, connections they have, more friends they have, more relationships they have. The older they are, the more able they are to express a preference one way or another. Those are going to factor into this. So it's a very, very challenging proposition. And so the importance of what I'm trying to really explain today is there are those situations in life. I have this amazing opportunity, my career is going to blow up in ways it never could if I take this job. It is going to be, yes, a 6-hour drive, or it could be a 2-hour flight, but hey, I'm making more money, and so I incur some of the costs of that, and I can find ways to make sure our children stay connected with their other parent. But it's a challenge, and it's a costly process, because when you go to trial, not only are you paying your lawyer and your spouse is paying his or her lawyer, but you're collectively, someone's paying the guardian ad litem or the child's representative. If the court appoints a psychologist to do an evaluation as to the best interest on this relocation or removal issue, that could be another $20,000, $25,000 expenditure, let alone if that individual is called in to come in and testify, and they could be testifying at $500 an hour or $1,000 an hour. I've seen $1,500 an hour for some of these experts to come in. So you're talking not even necessarily tens of thousands of dollars. You could be talking 6-figure litigation. Is it worth it? So my position is never to say you should or shouldn't do something. What I'm saying to you in today's episode, and what I would say to you if you were in my office consulting with me on these issues, is we really need to understand. We need to do the checklist over here, the pros, the cons. And if it's pretty close, there's some really good points here, there's some really negative points here. My job is to make sure that you're aware when you're about to spend a whole bunch of money that you have some sense of probability of outcome on this, knowing you start with an uphill battle. So be realistic. Go into this. Again, I'm not trying to dissuade nor encourage someone for doing this. I think practically speaking, in all the cases I've had, nobody does this thinking this is great, I can't wait to get out of here, right? It is an understanding, yes, there's going to have an impact on the family, but sometimes for certain families, it's the only avenue that they can pursue. It's so overwhelmingly in a litigant's best interest and in their children's best interest, because the court also understands the better off mom is doing or dad is doing, the better off the kids do. So they have to compare that with the relationship with the other parent. Very complicated. These are very emotional cases, very, very emotional cases, because if somebody wins in relocation, think about the parent who lost, and their children are being taken away to an entirely different state. I mean, process that for a minute. That could be devastating. Conversely, I felt bad for the woman in a sense. She made choices. She's an adult. She found someone she loved. God bless her. But the individual had his life already in a different state. And so while she then had to live kind of this dual life back and forth because her children were here, ultimately for the children of her former marriage, that was best for them. So very challenging process. And I would encourage you, outside of the really high net worth, complex financial cases that I handle, these are probably the type of cases that require the most strategy, the most planning, and the most understanding really from the beginning before you walk down that path. So if you're in a situation where you're thinking about it for whatever the reason is, if you're in the middle of a divorce and you have lawyers and you're thinking about this, you need to discuss it early. It's not something you want to be in a case for quite some time and all of a sudden say at the last minute, hey, I'm thinking about moving. What can we do? Okay? There's a lot that has to go into that. And so I encourage anyone, if you're interested in consulting over the issue of relocation or removing to another state, feel free to call me. It really is something that you need to put some thought into. There's a lot to it. And I hope that in today's episode, you at least understand as we, plow through the month of February and we're talking about child-related issues in divorce, this being a very nuanced issue, but complex, requires experience. And if you're in with somebody and the lawyer's never tried a relocation case, you need to make sure you're getting proper advice. So as always, I welcome anybody to reach out to me, whether it's an issue of relocation or removal, whether it's having to do with kids at all, financial issues, anything. You can always feel free to reach out and contact me directly. My email address is jmquigley@beermannlaw.com. Remember, with Beermann, 2 E's, 2 N's. My direct extension is 312-621-1225. At any time, feel free to call, schedule an appointment. Happy to give you some direction. And if it works out that you want to pursue something, or if you're looking to challenge or block someone from relocating your children out of this state, always happy to help with that as well. So as we move through the rest of the month, I believe we're going to have one more episode before this short month of February, thank God, because it's been cold, comes to an end. We'll kind of wrap up with the child-related issues, and then we're going to move into some of the financial issues, and there are many. And so we will be having a series of podcast episodes dealing with financial issues, trying to do them, again, issue by issue so that you can compartmentalize your viewing of the podcasts in a way that is really tailored to what your needs are. So for all of you who took the time to follow or listen, really appreciate that, and we'll look forward to seeing you at the next episode. Take care.